Good afternoon. Today's panelists are comprised of partners of Morris, Manning & Martin, and all of our panelists are part of the firm's COVID-19 task force, which also includes many other attorneys in the firm that are focused on the business and legal issues that are derived from this COVID-19 pandemic. The panelists are Bonnie Rothel, who chairs our risk management and litigation group and has a specialty in real estate finance; Tom Grabowski, who leads our hospitality group; Bruce Smith, who heads our construction group; and the last two members are Matt Sowers and myself, Lee Walker, who neither chair, lead, nor head any group within the firm. But between us, we have about 60 years of commercial real estate experience, and we're happy to be on the panel. Matt's practice focuses on multifamily, industrial, and retail development, acquisition and development, as well as specialty in office, industrial, and retail leasing. My practice is a developer-focused practice that covers a broad range of real estate assets. I do a lot of construction lending from the borrower side, and that's going to be my focus today. The issues that the pandemic has brought about impact operating assets because people aren't open. There are stay-at-home orders, there are operational restrictions, so cash flows impacted. And there is thus an inability to pay rent, debt service, salaries. In the construction arena, and there's plenty of construction that was ongoing when this started, you often have a construction loan. And the budget for the construction loan identifies equity and debt to cover the entirety of the construction process and should cover 3 years of interest, taxes, expenses, as well as the construction costs. So you're not having a lack of cash to perform. You have performance failures that you need to be focused on. And we're going to kick this to Bruce Smith, who's going to give us his insight on the construction industry right now.
Great. Thanks so much, Lee, and welcome everybody. Good afternoon. I'm going to kick things off here by giving a general overview of how ongoing development and construction projects across all industry segments have been impacted by COVID-19, what's happening now, and where we see things may be headed as we gradually, hopefully, emerge from the lockdown stage that many, many states have been in. Turning first to projects in the construction phase, obviously, it varies by state and jurisdiction as opposed to, is your project able to continue? Is it a lockdown? Is it allowed to continue? The experience that we've had here in Georgia, Florida, and Texas obviously is drastically different than projects and developments that have been completely shut down in northeastern states like Michigan, Pennsylvania, Massachusetts. By and large, most of the projects that we've seen that were a good ways into construction have been continuing, have been allowed to continue as an essential business or critical infrastructure. And so what does that look like? Obviously on projects that are continuing, progress has been slowed due to shortage or unavailability of manpower, required protocols such as social distancing, use of PPE by construction workers, temperature checks that have been instituted on many projects, social distancing requirements, and when a worker tests sick on a project, in most cases the projects need to be shut down for 72 hours, cleaning protocols implemented. So projects are continuing. We are seeing draw applications being funded, some in imaginative ways. In some instances, architects are using drones to gauge completion, or using contractors with GoPro cameras so that status complete during months can be recorded that way and pay applications certified and processed. Lee, for projects that have been shut down or suspended, what construction loan covenants have been implicated and have you been dealing with?
Well, cessation of construction is always a default under the loan documents, and these are pretty short time frames, 15 to 30 days. It's a negotiating point. You always want that to be extended by force majeure, so they're typically not tied together at the beginning of a negotiating process. So you got to make sure that you do have some flexibility. so that those time periods are extended. But typically they're going to have a cap on the total number of days that they can be extended. So even if you have flexibility within your loan documents, kind of depending on how long your shutdown or is, you may need to go to your lender for some relief.
Okay, yeah, that's great. Thanks, Lee. Turning now to whether your project has been allowed to continue or whether projects have been shut down or suspended, we are dealing with and have been assisting clients with notices that are being sent by contractors or designers for time extensions, cost and fee increases associated with COVID-19 and delays to the construction process. I'd like to ask to poll the audience to see how many of you have projects where these types of notices or these types of claims have been submitted or received, or you're in the process of dealing with. All right. Again, many of the projects across the country that our clients have dealt with are receiving these, and in many instances, they're what I call placeholder notices, where contractors or designers may notify you of an impact or are notifying of an impact, but are unable to quantify the claim. And obviously, there's going to be fallout in dealing with these kind of claims as we hopefully gradually emerge, as we move forward over the next 30, 60, 90 days. And many of these, the entitlement question will be driven by the force majeure or delay provisions in any given contract. And we've been spending a good amount of time analyzing that as well. Lee, how are these delays and delayed completion being dealt with, or are you working with the lenders?
Well, like cessation of construction, there's typically a completion date by which your basic site work, any offsite improvements, and the shell building components of your project need to be complete. So if you're going to have delay, you may be extending the date by which you achieve completion. Again, you have to go through the analysis of, does force majeure apply to a completion date? It doesn't always. Some lenders won't give you that, and you have to establish the completion date at a date that makes you comfortable. And so there is some flexibility, but you need to check that and make sure that you aren't in a situation where you need to ask your lender for some time extensions. Also, you want to be sure to do everything necessary to get the benefit of your force majeure delay. There can be provisions in your loan documents that you've got to notify the lender within X number of days to get the benefit of a force majeure delay claim. So be conscious of that. And when you're dealing with your contractor and you're making these decisions, make sure you've given the proper notices so you do get the benefit of whatever force majeure delays are available.
Great. Thanks, Lee. It was interesting. The result of the poll, 83% of you have said that you have not seen or had to deal with these types of notices, whereas 17% have. So I think that's a pretty interesting statistic. I want to ask the group another question. As we've gone through this COVID situation, several projects that we have seen, not many, have been suspended or terminated, either by the owner or by contractors or designers. Typically for business reasons, owners may elect to suspend the project for convenience or to terminate for convenience. The contractor or designer right to terminate is typically keyed to either non-payment or a shutdown of the project by the authorities having jurisdiction. So the question for the group, do you have a project that has been suspended or terminated by you as an owner or by a contractor or a designer? I'd just be interested in seeing what the result of that is, and then we can share that with the group. Again, we have not seen very many of those situations, but we have seen situations where, for business reasons or other financial concerns, suspensions or terminations have happened. Very quickly, What have we seen? Most projects that have been in the design phase have continued. Most projects, larger projects that have been in the GMP stage, the pricing stage, the active contract negotiation stage, have been suspended or are standing down. Most projects at the RFP stage have also been suspended. And from talking with folks out there in the marketplace, I think this is on the belief that we are, fingers crossed, emerging or starting to emerge from the COVID lockdown, and that these projects are going to look better 30, 60, 90, 120 days from now from a pricing standpoint than they do right now in terms of economic feasibility. I think the belief is that construction pricing, design fees, and the labor market are going to be more favorable once we emerge on the other side. So what's next? Looking at our crystal ball, I think that we will be negotiating and working through these delay and impact claims. Projects will be repriced as material and labor costs fluctuate. There undoubtedly will be an intense renegotiation or negotiation on new construction contracts and design contracts of the force majeure provisions, the delay provisions and termination provisions. In the old days, and I had a call with a client yesterday about a contract that we assisted them in negotiating that was very favorable to the owner. It said in the event of a force majeure delay, which includes epidemic, the contractor gets time, but no money. I think the days of that contract provision in the new market are numbered. And finally, I think that the force majeure negotiation will also have an impact on project pricing. And Lee will talk about this in a minute. To the extent that force majeure provisions are renegotiated and the contractor is entitled to recover both time and money, obviously owners from a financial standpoint need to build that additional cushion or budget in the project contingency costs in the event that, God forbid, we find ourselves in a COVID 21, 22, 23 world. And lastly, there'll be a heightened importance, as Lee has indicated, of coordinating the provisions in your design construction agreements with the requirements in the loan documents. And with that, I'll toss it to Lee for a discussion of that point.
Yeah, what we're going to see, I think, coming out of this is a renewed, when you're negotiating your loan documents up front, is a renewed focus on what constitutes force majeure. In loan documents, that definition is typically a lot shorter than you would see in a construction contract development management agreement. Borrowers are going to be a little more emboldened to require that the lender address specifically these things. I've always been a fan of having the force majeure provision include anything that is a force majeure under the construction contract, so that if the lender has a delay, I have a delay. The other things that are going to be focused on is, there's typically, like I said, a limit on the number of days. And I don't know if you bifurcate the concepts of force majeure issues we've all lived with in the past, such as, casualty, and the pandemics are treated differently. And then also, what does the force majeure provision apply to? You're going to be, again, in loan documents versus other types of documents, force majeure applies specifically, not generally to all of your obligations. So again, force majeure provision, how much time you get, and to what is it applicable are going to be the new focus.
Lee, are you seeing any appreciable increases in caps on total force majeure periods or cessations of construction for shorter periods as you're negotiating loan documents right now?
I haven't negotiated any since the pandemic started. It's shocking that, this has really only been around for about 60 days is something that we've all, realized is such a major crisis. But different lenders have different levels of comfort with it, with the cap. And some will go 120 and others will stick with 30 and just say, make sure your completion date already gives you enough cushion.
Lee, one of the things that we've been dealing with both on behalf of our lender clients as well as our developer clients, is that there needs to be a connectivity and a causation between the force majeure clause and the underlying event. And so what we saw, particularly from the construction phase, is that those projects that were going strong, entering into the COVID-19 situation, continued to go forward. And it's really those projects that were failing or struggling before we entered the COVID-19 situation that then, ultimately have come to a halt as a result of both the pre-existing situation as well as the COVID-19 situation, putting basically the nail in the coffin. So as we've been advising clients on whether or not a force majeure clause applies, we've also been looking at what is the causation? Was that project destined to fail anyway?
Yeah, that's a good point. A lot of people are using the COVID-19 pandemic to request relief for any number of things, rent, time, and the question that the person granting relief has to ask is the pandemic the cause? Do you really have a need? Prove to me that the pandemic is the reason that you're not meeting these timeframes.
Yeah, no, Lee, that's a great point. We have several projects where, from the owner's perspective, the project should have been completed long before the onset and the outbreak of COVID-19. And then COVID-19 comes along and the contractor is trying to piggyback on the COVID-19 event, when in reality, the project should have been completed 3 to 6 months before COVID ever occurred.
Lee, you mentioned the effects of rent and establishing a nexus between that and ability to pay and the pandemic. And obviously that's an easy connection to make on the retail side, but we're seeing in many cases on the office side, a much more challenging demonstration of financial impact on the part of tenants.
Yeah, I polled a couple of our office developers and they're holding the line pretty hard and requiring that there's some real proof that there's an impact.
That's right.
I think we're nearing the end of our construction discussion. The last thing I wanted to mention is if you do run into cost overruns, delays can cause an increase in cost. Even if pricing is going down, if you've ordered a bunch of materials and you can't incorporate them in the project, all of a sudden you're renting a warehouse and storing, the building skin, that could be a huge amount of money. So within the loan documents, you're going to have budget flexibility provisions. You may be able to use cost savings to cover cost overruns in a different line item. You're going to have a contingency that you will have available, and it's the reason it's there if costs increase. So you may have the ability to deal with some budget increases or cost increases within your documents without lender's approval or maybe with their reasonable approval. But if your project is over budget and it's over all of these flexibility provisions, you could find yourself in the balancing provisions of a set of loan documents. Typically it has an on ability to monitor the construction and available debt and equity. And if they think the project is going to cost more than is allocated in the current budget, they can say, well, you need an extra $750,000 to complete this project. And they'll either require the borrower to fund that directly until the loan is back in balance, or the less pleasing option is they may ask you to fund that amount to the bank and they hold it, and those are the dollars that they disperse until, again, the loan is back in balance and you're dispersing loan proceeds. So that's a negotiation you want to have up front. It doesn't matter what the reason that you're over budget, this provision is going to be something that can kick in. So I think
before we end construction, I just want to ask one question to Bruce and Bonnie. Are you seeing any the sureties getting brought into these construction projects at all? The problem ones?
Yeah, absolutely. We are. In each and every one of the scenarios where there has been, a work stoppage or a contractor walking as a result of the COVID situation or situations that preceded COVID, the sureties are being brought in. And I have to say 9 times out of 10, the sureties are denying the claims, or at least not being particularly quick to act. What we're recommending, by the way, just to kind of piggyback on something that Lee said and tied into Tom's question, is we're really recommending that borrowers and lenders try to work together and have an open dialogue and a communication. There have been a couple of scenarios where borrowers have unilaterally taken a quick decision without consulting with their lenders and without working with their lenders. And I think that's causes the most likelihood of the project failing. Whereas if a borrower and a lender work together and the borrower presents a proposal to the lender that's well thought out in terms of bringing in additional investors or equity, or trying to get some concessions with the contractor, or working through, a forbearance, where applicable, and we're going to talk about that in, later on in this dialogue, but just kind of working through that together with a well-developed, well-thought-through plan is usually preferred. I had another question too, before we move off of construction, and I was curious what you all were seeing. But my sense is that there's a real significant tightening in construction lending, new construction lending. Is that everybody else's take? The construction lending that's already been issued prior to the COVID situation is, muddling through, and in some instances, going through pretty well. But there seems to be a tightening of new construction lending.
I think that's true. That's been my observation, although I will say relationship lenders have, I think, remained sort of in the same boat. And we've seen more uptick on the regional and community level as opposed to national. There's certainly, I think, fair to say that there's been a decline in construction lending from national institutional lenders.
And it may depend on your asset class. Industrial is still a hot area for development, and the hotel industry is probably suffering significantly from a lack of available financing. So that can play into that as well.
Certainly, you're correct.
Okay, so let's move on. Matt, you were going to give us some of your insights on some of the construction the purchase contracts for developable assets that you've been working with for with some of your clients.
Yeah, so observations, of course, this is development pre-construction during various phases of purchase and sale agreements. Of course, as Lee pointed out, industrial has remained strong, and I don't think that's a surprise to anybody given the significant increase in online ordering and deliveries and fulfillment and distribution centers. Multifamily appetite development really seems to be consistent in terms of deal pursuit, but as I'll discuss, there are certainly a number of challenges to it. And retail development is not at a complete standstill, which might be expected, but there certainly has been a precipitous decline. And office, I think, has declined significantly as well. And my colleague, Tom Grabowski, will discuss hospitality in detail. But what we're seeing in purchase and sale agreements, if you're developing an unentitled site or needs to be rezoned, typically have a deal life of 12 to 24 months. And those deals are all more or less within 3 distinct phases. The first being inspection period, which we also should probably call the capital raising period, because no one these days is exiting inspection periods without having the deal capitalized. As is not surprising, developers tend to be fairly reluctant to invest much in pursuit these days, given the uncertainty of the capital markets. So they're trying to get more time from their sellers, and sellers are typically being accommodating. I think, this is a situation that there is sort of a sense of humanity, and people tend to recognize that, hey, we all need to figure out how to make this deal work. It's a problem we're all having to deal with. It's not unique to anyone in particular. So deals that are in inspection periods, they've either been terminated, but I'd say at least 75% are just getting extended to provide more time. And as I said, sellers are fairly cooperative with that. I don't think they see a lot of value in going back to the market at this point. Those deals that are post-inspection period, but during an approvals or an entitlements period or a rezoning, obviously those things tend to take a longer period of time and are generally going to be conditions to closing. So while there is still refundability of deposits subject to fulfillment of those conditions, there's also a higher investment in the deal on the developer side and greater time involved on the seller side. So I think that dynamic is leading a collaborative, I guess, outcome in terms of developers getting more time through obviously no fault of their own. A lot of local jurisdictions have been either not having hearings or meetings or been doing them virtually, but in any event, there have been significant deferrals. So it's just thrown the chronology of the deal off considerably. One thing that we are seeing in connection with extensions of the rezoning, entitlements, approvals periods is sellers asking for either additional earnest money, release of earnest money, and in some instances increases the purchase price. Of course, as you might guess, increases in purchase price are not, there's not been a lot of success with that given the already uncertain capital markets. That just creates additional obstacles to making deals pencil. Deals that are post entitlements, approvals, rezoning period, et cetera, that are moving toward closing. We've seen several of those close. We've also seen some instances where equity investors have pulled out very late in the game. A lot of national institutional equity investors have been reassessing their entire programs, and that's caused either deals to mostly be delayed, in some instances to terminate. Probably the best thing that you can do on the development side, and obviously the contrary would apply to the sales side, is just to have it's like we've been talking about in every context here, but to have clear and open communication with your sellers and explain just factually, here's where we are, here's what we have invested in the deal to this point, here's why we need more time, here's our revised schedule, we need you to work with us. It doesn't make sense for you to go back to market and hit reset. And first of all, good luck getting your deal signed. But secondly, it's, you're starting the clock over, and in this era of uncertainty, I'm your best bet. So stick with me and we'll get through this and we'll get the deal done. And that, generally seems to be a successful approach. In terms of, as I mentioned, equity market seems to be tighter than the debt market. We are still seeing debt. I guess I've worked on half dozen set of construction documents since the lockdown. And I am seeing lenders be more sympathetic to giving additional time and cushion for construction schedules, expanded definitions of force majeure, larger or longer caps on total force majeure delays, where you might have had 90-day total force majeure delay for a project previously. Now we're seeing 120 to 150 in some cases. And the shorter cessation of construction periods, that might be 30 consecutive days, now we're getting some relief, 45 to 60 days in some instances on those. So I think that, people do seem to be trying to find ways to make their deals work. Bonnie, what are you seeing on the debt side?
Yeah, so as I mentioned earlier, not only do we see a tightening of new debt, but there has been an overwhelming volume of new requests for forbearance, and the lenders are definitely struggling to keep up with the volume of requests that are coming in. And that's why one of the reasons I did suggest, when borrowers go in for different types of forbearance requests, they go in well organized with a plan, and not leave it, blanket open-ended requests, for that would make it very easy for a lender to reject it. There's also, certainly been a lot of issues that I've seen with construction projects that have reached completion but are having trouble getting across the hurdle, with lease up and other transition issues, be it because of permitting issues. Some localities are being slower at issuing permits, and some of the local organizations are actually closed, and they're not doing that. Some of the appraisals and surveys that are required post-construction aren't taking place or are getting pushed back. So there's definitely a lag, if you will, between those projects almost at the finish line and getting them across the finish line. Probably also because of people pulling out on funding, investors pulling out at the last minute, or difficulty getting some of the last items that are needed for projects. We have several projects right now where I've been told that the construction was just about complete, but there's different items missing from the product that were being imported from overseas. And for those instances, the projects are either stalled or needing to transition without those last items, and hopefully they'll come in soon.
Okay. I think we want to turn to Tom and Matt, who have much more experience. Like, we're moving on from construction into operating assets. Tom in particular is focused in hospitality, has given him some insights. I'd like to hear from him on how that industry is responding to the COVID-19 situation.
Yeah, well, following up on Bonnie's points about lenders, obviously the hospitality industry has been impacted severely, and all our clients are reaching out to lenders and trying to get some relief for a short period of time while they figure out the best way to work through a final solution with that lender. And it's been our experience that the CMBS lenders basically have been a disaster to deal with. They're unclear of what the servicer can do, when it has to go to a special servicer. And a lot of people just want to get some short relief from the servicer and not get into the special because of the additional costs and that are associated with that, with interest rates, and they'll start appraisals and testing and things like that. And so I have not seen a single extension granted with a CMBS lender yet. But with the balance sheet lenders, it's been a different story. They've been very helpful. And people always ask me, like, what are you seeing? What are you seeing get granted? So I wrote a few notes down of the things I have been seeing. Basically, a 3-month interest deferral, a 3-month amortization deferral, or even greater on the amortization side. Waiver of FF&E reserves, and that's primarily because the franchisors are enforcing their quality programs at this point. Well, they may be a little bit, but so all these PIPs and things that people are saving up for aren't required at this point, and they can use the FF&E reserves for operations and debt service and the like. They're also, so I said they're waiving the FF&E reserves and also allowing access to them. The one thing I am seeing is the lenders are very concerned about property taxes. And so before they'll let money out of the FF&E reserves, they generally make you fund up your property tax reserves so they know that that lien won't be forthcoming. The extension tests are getting reduced. The ongoing DCR tests are often waived as long as you're willing to put some type of dividend blocker in and not take distributions in that time. So that's what we've been seeing on the debt side. Another thing that we see a lot of that we've had to deal with is what do you do with the asset when you're only having 2 or 3 people show up a night? And you know, the options are stay open, shutter the asset, or try to find an alternative use. We have found that alternative uses have been almost impossible to make happen. And the reason is not only is it just like shuttering the asset, you have to deal with lenders, franchisors, third-party management companies, getting all these people on board to do it. But generally, it's a governmental entity. And with the sovereign immunity and the interplay of insurance, there's basically will end up being no indemnification or insurance protection for the owner. So that has not been something that's worked out well. The temporary closure we have seen, you have to go deal with lenders. The franchisors have been very, very helpful in that and granting the closure. Management companies have been all over the board on giving up the management for that time period. And there's other things that we have to look at when we do those type of things, like, is it a legal non-conforming use that if you shut down, that you're gonna have to go back and try to, and the zoning can be an issue coming out of that. And we also don't have any idea what the local authorities are gonna require. You know, you shut down your hotel for 6 months, are they gonna come back in and almost review it for a new CO, or are they just gonna come in and check the safety of the pool and let you open? That's another challenge that it's just an unknown in our industry. Those are the type of things we're seeing.
Hey, Tom, question for you. Does the Paycheck Protection Program, loan program, is that a benefit to the hotel owners versus a shutdown of the project?
Well, that's interesting because while you have to use 75% of it to pay employees, a lot of people are finding it not nearly as helpful as they thought it would be when they first came out with the program, because essentially you'd be paying people to work when there's no reason for them to be working because there's no guests in the hotel. But yes, a lot of people have accepted the money, kept employees, and that's pretty much the purpose of the program. And but it really isn't. It isn't exactly the way they would want it to work, because I know there's a big lobby right now to move the covered period to the end of the year. So you'll actually be able to then spread that money over a longer period of time and keep people employed longer. And that would be a better result for the hotel companies.
Tom, anecdotally, talking with a couple of retail operators, I'm hearing the same thing, that the outcome from their PPP loans is not probably exactly what was intended, in that they're paying workers not to work. Meanwhile, they'd like to allocate a larger share of that to be able to pay rent, because that creates obviously a longer term problem and issue and pressure on their business.
I understand that. Matt, what else did you have? Were you involved in this one too? Are you?
Yeah, so kind of dovetailing into that, obviously the retail sector's been hit very hard with mandatory closings. Of course, stay-at-home orders are getting relaxed or expiring gradually across the country. Many already have. The interesting thing that I've seen is that there's not typically, or at least landlords aren't agreeing that there is a real legal basis for giving retail tenants relief, but they recognize as a practical matter, they're not going to be in a position to be able to pay rent because they're not operating. And it creates, there's a whole slew of ripple effects associated with co-tenancy and operating covenants, and those things will probably be explored in the future. But I think the heavy focus these days really has just been trying to come up with solutions among tenants, landlords, and lenders that try to minimize the damage and maximize the long-term viability of a shopping center. Most of what we're seeing on the retail side are really deferrals. Sometimes they're amortized over the rest of the term. Sometimes they start a year out and then are amortized over the rest of the term. Sometimes term is added. Sometimes there's a blend of a lower rate and percentage rent. There's been a lot of creative solutions that we've seen in the market. That the encouraging thing about it is that people seem to be taking a very collaborative approach to trying to solve for that problem.
Hey, Matt, relative to those types of deals, how are you seeing them documented?
Well, that's a really good question. In many instances, more than I've ever seen, they aren't being documented. A lot of landlords are just doing it verbally on a month-by-month basis because they don't know what to expect. They don't want to overcommit to a rent reduction or deferred rent if in 30 days things are back to normal, which I don't think most of us expect, but there are some situations where that could be the case. So I've seen a number of situations where landlords just say, look, you can pay half rent for this month and we'll revisit next month, or pay us your residual from your PPP loan this month and we'll revisit next month, right? It's been a very flexible approach. And I think that some of that may be driven also by minimizing or a desire to minimize lender input. No.
Yeah, because the loan documents are typically going to say you can't make material modifications to your leases, particularly the financial components of those leases. And
Right.
maybe the landlord's maintaining the position to be able to say, well, listen, they just didn't pay rent. They're in default. I haven't done anything wrong. They just didn't pay rent. And it should never be a default under a set of loan documents.
Right. And I think there's something, probably a component to it of, it's so temporary. I don't want to go through the headache of having to get my lender, especially if there's a servicer involved, in trying to figure this out, because by the time that happens, the damage could have already been done or the situation could have reversed itself. So that has been the verbal type amendment has been an interesting development that I've seen. In the office sector, and Lee, you alluded to this earlier, a lot of office tenants are not really heavily impacted by the stay-at-home orders. I mean, certainly some are, but our office clients, I don't know that we necessarily even had to encourage it, but we have seen them really demanding a demonstration from tenants with numbers and facts as to how they're impacted before there's really even a discussion of any sort of rent relief. And again, same thing in office. When we do see rent relief, it's really not so much rent concessions or reductions as it is deferrals. On the multifamily side, this has been a pleasant surprise in talking with a number of multifamily owners. Reports on April rents were that they were only down about 5%, which really surprised me. And the numbers I've heard, preliminary numbers on May, sounds like there's a slight additional decrease, but not where anything as much as probably, or at least what I would have guessed. I have understood that, in some instances, people have had, multifamily owners have had great success with virtual leasing, where people don't actually even get to see a unit. in person. Others have not had as much success, and there is a return in many states to in-person leasing activity that has started and or will start incrementally as the stay-at-home orders change or expire. I guess as far as rent relief that we've seen on the multifamily side, some have granted concessions or abatements. Some have granted in hardship cases, which is not a high threshold. It's just signing a hardship certificate. The ability to terminate a lease early without penalty. If somebody can move back home with mom and dad, those situations. And of course, we've seen payment plans that are tailored to reflect the current state of affairs.
So beyond these issues which we're dealing with that are among the players on the field, the contractors, owners, lenders, landlords, tenants, there's legislation out there that can be applicable, and Bonnie and Tom, I think we're going to speak about the CARES Act and the Small Business Association loans and how they're seeing these play out.
Yeah, thanks, Lee. So to start with, under the CARES Act, the PPP loans, I think, have been successful. I was noting when Matt was indicating that the tenants are by and large still making their rental payments. I think that is probably in large part because, at least temporarily, there is money to be had through additional funds that are available through the CARES Act, as well as because of the restrictions right now that many states have on evictions. So that could be why Matt's saying that there have not been as many rental defaults recently. But under the CARES Act, for those of you who aren't as familiar with it yet, there is, up to $10 million that can be obtained. And for most of those, we have seen that the existing banking relationships are needed to get those loans. Of course, as you may have seen out there, there have also been a number of lawsuits that have been filed against lenders for requiring an existing banking relationship. But there's a reason for the requirement that a lot of the banks have, that there be an existing bank relationship for those funds. And that's because it makes it much easier for the banks to get a comfort level with the prospective borrowers. In order to take advantage of the PPP loans, the business owner does need to have, it's intended for the smaller businesses, 500 employees or less. And we were talking earlier, I think Tom mentioned, the fact that a lot of borrowers, particularly in the hospitality and retail sector, are reluctant to take the PPP loans because 75% of that PPP loan, in order for it to be forgiven, does need to go for payroll. And up to 25% can be used for other purposes such as mortgage interest or rent or utilities. But when you have a retail establishment or a hotel that isn't having clientele at the time, it becomes difficult to spend 75% on employees if the employees don't have anything to do. So I think that's one of the issues with the PPP loan. The other issue with the PPP loan, and I think everybody is waiting for further legislation to know whether or not those funds are in fact going to be forgiven, or what those restrictions are going to be. The program seems to keep changing, and every other week you hear a new guidance being issued about it. So although right now it's understood that the loan will be forgiven if within that time frame, I think it's the 2 months time frame, 75-25% rule is followed, and those funds are used. That is still up in flux because there's talk about extending that time frame. There's also talk about additional scrutiny that might be made on the borrowers who take those loans as to how those funds are actually used and if the funds were necessary in the first instance. So I think that although the loans are out there, and I think a lot of people are taking advantage of them, a lot of borrowers are also giving the loans back. They're afraid, what will happen. Will they be able to pay it back if in fact it's not forgiven and nobody knows what's going to happen, a few months down the road, if their business will actually remain current and capable of being continued or not. Another issue, I think, for some companies taking the PPP loans is the fact that you have to make a representation that you're not getting other government funding, and that might prohibit the entity from getting additional debt down the road. It also might affect investor requirements. So, we have been advising businesses that are seeking to take the PPP loans to check on their other lending obligations as to whether or not that will have an effect. But Tom, you've been also dealing with the economic injury disaster loans as well, haven't you?
We have early on, and that, I believe it came out before the PPP program. And
Right.
It really wasn't workable in the hospitality setting because if you get it to a point where it was over $10,000, I believe, you had to grant security. And so you're basically putting a second mortgage on the hotel, and for those amounts of money to get 50 or 100 grand and try to get lender consent and things like that, it didn't become worth it, and the PPP became much more attractive. But I will say that when I was talking about the hotel loans and things that people are seeking, is every client we have seeks a PPP consent, because most loans, all loans that I work on, have limitations on additional indebtedness. And so you can't go sign up for a $6 million PPP loan without lender consent unless you're willing to roll the dice that they're not going to default you on that. And lenders have been very, very accommodating on it, pretty strict on making you agree to use your best faith efforts to get it forgiven and put you in a little box there. So it doesn't become additional indebtedness in the future. But the PPP was much more attractive, but as I said earlier, it was not the perfect cure. And I think yesterday, Bonnie, actually, they came out with some guidance where that if you're under $2 million, there's going to be very little scrutiny of your loan, if any. Yeah. And I think they said they also came out with something along the lines of, if they determine that you didn't deserve the loan and you pay it back, there will be no implications. Because a lot of people thought, that even if they made a mistake and thought their faith, somehow they could end up in, being prosecuted. And I think the guidance yesterday made it pretty clear that wouldn't happen. So I imagine there'll be more people, if there's any funding left, feeling more comfortable signing those certifications.
Yeah. We've had clients who have waited a long time in the queue for the processing of those loans too. So I guess that's the big question. I think the first round of funding went so quickly, and I think the second round of funding also has been exhausted. There's a couple of other areas of relief that have been out there that some of our clients have taken advantage of, and that's another aspect of the CARES Act, which provided for forbearance in a multifamily program where there is, in fact, a hardship resulting from COVID-19, where there's a government backed loan or a government-backed program underlying the housing program. So we've seen that a lot with our FHFA multifamily loans, through Freddie or Fannie, as well as through HUD and the USDA Rural Housing Program. That's an interesting program as well, because it allows up to 3 months of forbearance relief for the borrower. There's very limited criteria other than showing causation, showing that there is an impact that COVID-19 has had on the project. The interesting part, that we are seeing is that the lenders were certainly overwhelmed with a number of requests, and many owners were actually seeking the forbearance protection. But then come May, about 40% of those who sought forbearance actually didn't use it. They made the May payment, which I think is a good sign, that some of the borrowers are able to, and in fact, making those payments despite having obtained the forbearance relief under the CARES Act. There's a number of states that have had interesting moratoriums too, and that's probably impacting the environment. Some of the states have specific forbearance related requirements that I think would be applicable to some of our borrower clients. It's also still anticipated that there's going to be additional forbearance expansion under the CARES Act. So we're waiting to see how that might open up for some other sectors, as well as to address how the forbearance relief that has been issued may wrap up in terms of other accommodations that might be required under the program.
Okay, so at this point of the program, do we just want to, I've got a couple of questions I wanted to ask, and maybe it's kind of a what's next, and maybe some questions from the audience. One question I wanted to ask, and I think, Tom, particularly to your industry, has business interruption insurance been something that hotel owners have made claims under, and have you, what's your experience in that?
I think everybody dusted off their policies. A lot of people took a stab at it, and I don't know of anybody who's been able to make a BI claim that was funded under this whole COVID issues.
Yeah, certainly that litigated. I've heard snippets of on the news about maybe a class action suit against. I don't know if that would decimate the insurance industry if every business interpreted to include law to the to the COVID pandemic, but that'll be something that'll play out over time. One other question, I mean, as we have all experienced stay-at-home orders and quarantining, and my wife literally has not left the house except to take a walk around the neighborhood for 7-8 weeks now. When we look at the office sector moving forward, do we think the experience of working remotely, and I think, now as opposed to 10 years from now, much more manageable, everybody's much more technically savvy, even somebody as old, able to participate in this program with minimal assistance from the IT department. But how do we see business owners, employees, and as opposed to getting those breaks when the kids and one of the significant others has left the house? Is everybody going to rush back to the office, or has remote working become something that's going to be more widely embraced?
One of the things I'm hearing anecdotally is that some of our project owners are changing their, reconfiguring their space for an idea that when we come back, workspaces are going to look different. So I think on that front, I think, there may be a new wave. I think while some people may feel that working from home, is something that's still beneficial, I think that the office space out there is trying to change, to conform to, the new, what might end up being the new norm. It's interesting, just a few months ago, you were hearing about these open space offices, which was becoming the then new norm. And I think we're going to move away from that common area office space and back to perhaps a more traditional space where people do have their own closed quarters.
Yeah, no, Bonnie, just to follow up on that, Lee, intelligence from the design community, it's the give me back my cubicle movement. And,
right.
It's a real thing because people are concerned about, open spaces and, even within our office, it's not completely open, but, when you walk past someone, in the hallway, it's a real concern. But, there's been a lot of discussion in literature, and I know, a lot of the design firms have been approached to basically go back to the day of the cubicle.
Yeah, and some of the business model of the companies like WeWorks, which is basically a space sharing organization. You literally bring your laptop in and you have, a chair or part of a bench and a table, and you can work there. And you're literally renting about 4 square feet. And you wonder if municipalities are going to start saying, from a building code perspective, you can't pack people in like that. And you're going to have to spread them out more, which would be great for the real estate industry.
Hey, Lee, do you think it's time to go to question and answers? It's been a little over an hour.
Sure, absolutely. Do we have questions that have been posted?
Are there any questions out there?
Actually, there are a bunch of questions, but before we go to the question, I think the answers to the last poll were kind of interesting. The question was, after working remotely during the pandemic, is moving back into office space going to be the preferred way of conducting business, or do you prefer working remotely? And of the participants on the in this group, it seems that 39% said they would like to see back to business as usual in the office. 11% said they would continue working from home, and 50% said they would like to find a new balance of the two, which I think closely aligns to what we were saying as well.
What other questions do we have? So,
I've seen a number of covenant busts and calls on personal guarantees. Is there any protection or insurance to purchase available to use in negotiating with the lender? I myself have not, during this period, seen any calls on personal guarantees.
Yeah, I don't know of any insurance. I will kind of warn you of written communications, especially with the CMBS lenders coming back to bite you with the SPE covenants and, admitting your failure to inability to pay your debts in writing and things like that. I don't know how a lender wins that recourse, but a lot of times that is a recourse event. So just be very careful when you are sending in your letter saying I need loan relief because I can't pay. Excuse me?
I think we've all seen covenant busts.
Yeah.
But I'm not, Bonnie, are you seeing any calls on guarantees? It might be early.
I've certainly seen demands on guarantors, but I don't know that anything would be deemed an actual call on the guarantee yet. I think that there are still parties, trying to negotiate. And I think that the guarantors have been brought into the mix during those negotiations. Like I said earlier, I do see, for the most part, a willingness on parties, all sides, to try to work through some of the problems and work through some of the issues. But I think the guarantors are going to get brought in. And as a matter of fact, one of the things I was going to address, and I know we're running short on time, is part of what, this wave of the future is going to be is trying to avoid defaults, after these forbearance periods are over, after the things settle back down, how many of these projects are going to be able to recover, and, whether we're going to be looking at, number one, bankruptcies. There's already anticipated increases in bankruptcies, as well as, significant new litigation that's, already been filed. We've been following litigation on a daily basis, and record numbers of new cases have been filed relating to COVID-19, and a lot of those cases are going to be heard over the course of the next year or two. Default rates, are at an all-time high. I pulled down some figures on default rates recently, and in the lodging arena, I think it's up 35%. Retail is 18%. And then office, multifamily, industrial is still significantly lower. I think all a little under 5%. But those numbers are rising, and we don't know what's going to happen after these periods are over. But I think, to answer that question, I definitely think the guarantors are going to get pulled into it.
Yeah, just Matt, why don't you get to the next question? But I do want to say that I have heard of insurance products out there that do cover guarantees, but I don't think they cover guarantees that are defaulting or imminently defaulting loans. I don't think you get that insurance at that point, but there has been insurance products out there that would, in a normal origination of a loan, cover a guarantee, but I don't think it would be available when you're in trouble.
Yeah, Lee, do you want me to take the next question on construction insurance?
Yeah, go right ahead.
Yeah, the question was asked, are we aware of any insurance products that will cover delays resulting from pandemic type events? Short answer is no. I mean, your traditional 3 products that will be implicated during the ongoing construction project. One is professional liability on the part of the design team. That is only triggered for delays caused by negligent acts or omissions of the design team. Obviously, COVID-19 does not fit into that bucket. Then there's CGL coverage, liability coverage during the construction operations, and excess that sits on top of that. Same answer, the coverage there is triggered by negligent acts or omissions by the contractor or subcontractors, and the coverage is limited to bodily injury or property damage caused by the negligence. Again, you can't blame COVID on contractors, no matter how hard you try, so that piece doesn't really apply. And the third building block is builder's risk, which doesn't cover delay damages. That covers damage to the work itself. And, people are trying to make this argument in the business interruption world, but, I think it's a reach. Whether you're building, if it's infected by COVID, does that constitute damage to the work itself? Nobody really knows. But again, I think it's a reach. So that's what I've got on that question.
The next question I see is, what do you see happening in about 60 days when most of the forbearance have expired, particularly projects with issues? And think about that. I mean, I take the position that 2 things. 1, the lender actually wants to loan you the money, even though all loan documents, once read, make it seem like they don't. And 2, the lender doesn't want to own your project. Even though if you read the loan documents, it seems like they really do. And so if you're dealing with lenders with which you have longstanding relationships, a lot of our clients have construction contracts across the country. They've got multiple lender relationships, and those lenders are excited to loan them money, and they have a track record. And I think there will be more forbearance because there's going to be a long-term view, because we're all going to be here 5 years from now, and you want to be on the list of lenders that this apartment developer calls, or this industrial developer calls, because that's their bread and butter. Again, even though sometimes it seems like it's not. With projects with issues, I guess there's also this distinction between loans that have been securitized, and so you're dealing with a servicer. Tom spoke to that, and relationship lenders, and which is a great term because they care. they care about you and your future business. And the servicer, you don't have a relationship with the servicer. It's like you just don't. They're heartless, soulless beings. But projects with issues, again, Bonnie's mentioned that she's seen more bankruptcies. And so if you have other issues and the pandemic has come along, maybe people will be more sympathetic to you that you mismanaged your project for 2 years, but now you're the beneficiary of the COVID-19 situation. You can blame it on that, and maybe there'll be some more sympathy for you, even though the real tragedy was the way you managed the project the first 18 months. Bonnie, you had any thoughts on that?
Yeah, first of all, I think some of my servicer clients would definitely take issue with them being called heartless, because I can tell you they're not. That being said, there is a reason for some of the provisions in the loan documents, and I think that what some of the lenders and servicers are going to be struggling with is the fact that they also have investors and other government program requirements that need to be complied with in order to keep those loans in their portfolio in a performing manner. So, I think you're right. I think they for the most part, the lenders and servicers do want the business, and they do want the repeat business from the borrowers, and they're looking for long-term relationships and long-term repeat borrowers. But where you have the one-offs and the project borrowers who might have been mishandling, or might have had contractors who were mishandling projects, or might have been heading for problems, at the outset, 2 months from now, the foreclosure restrictions are going to be lifted. The courts will be back open. And I do think that, some of these defaults are going to need to be resolved one way or the other. And it might be through further negotiations and additional forbearance relief. But I don't think that the banks or the lenders are there to give away free money either. So I think that they're going to, certainly have to comply with their program requirements in order to give additional forbearance, which, I think under some programs that might be possible. I remember, I have enough gray hair to remember some of the prior go-arounds of this, and I remember the modified workouts of the late 1990s and early 2000s, where programs were restructuring programs came about in order to avoid massive defaults, and hopefully some of those will be looked at as well.
Yeah, and Bonnie, one other thing, because I know I am aware of it, but I'll bungle it if I try to make a positive statement. Lenders have a certain amount of flexibility, and that's why you're getting these 90-day deferrals. And if you go beyond that, then a loan becomes a bad debt that has to be listed and reported. Is that correct? And is that going to inhibit future flexibility from the lenders?
Yeah. I think that's exactly right. I think that, depending upon which loan program you're working through, there's all sorts of reporting requirements. If you're dealing with a HUD loan, has HUD insurance. So if it's in default for a certain amount of time, absent a government approved forbearance program like what we're dealing with now with the CARES Act, that loan needs to be noticed as a default, and there's strict requirements as to the deadlines to assign those loans to HUD. Likewise, in the FHFA arena, there are deadlines and restrictions, and in the other investor models, the same holds true.
Okay, so I think we're down to the end of our program. I didn't see any other questions. Does anybody have parting comments?
Do we have any results from any of those polls that we haven't yet shared? I'm not sure if we've shared all the poll results. And I'm wondering if there's any other questions out there as well. Nope, it looks like all the poll results have been shared.
Yeah.
Amelia, are there poll results we can share?
No, it looks like they have all been shared.
Oh, okay,
Yeah.
just not with, I don't see it. Okay, well, I think we're going to wrap up the program now. Thanks for joining us. It's been, I've enjoyed the conversation. I hope you have. And best of luck out there, everybody. Be well and stay safe.
Thanks, everybody.
Thank you for moderating with us, Lee.
Thank you.